Hello, hello. Can everybody hear me?
Yes.
Okay, wonderful. Good afternoon. I trust everybody is well today. I can't believe we're back to another Thursday already. We just did last Thursday, we just did Saturday, and then yet here we are. Okay, let me just, who's here? Most of us are here. Did everybody have an opportunity to do the assessment questions for accounting?
Good evening, everyone. Mr. Wilkinson, I would like to be the first to say that I haven't gotten a chance as yet. It's been a really rough week for me.
Indeed.
But I promised I would catch up this weekend.
That sounds good because we still have today's lecture to do an assessment and of course Saturday session. So you'll have an opportunity to do that. In the meantime, we'll go through the accounting and you can just kind of tuck it in and we'll move forward from that point.
Okay, thank you.
Great stuff, great stuff. As you can see, honesty is still the what?
Policy.
Absolutely. Way to go, Deandra.
Good evening, Mr. Wilkinson. While we're on honesty,
Oh my God. Did I open a can of worms here? Okay, Alicia, let it rip.
I have not done the assessment. I
Okay.
am just listening in class today and on Saturday. I'm packing now to travel. On Saturday, I'll be traveling. So I'm just here listening. So,
Oh, you getting ready to have fun while the rest of us are suffering.
yes.
Yeah. What,
So
what, what time
I'm
on
in class, but
Saturday?
not. I,
What time on Saturday are you traveling?
pardon?
What time on Saturday are you leaving town?
No, I'm going tomorrow.
Oh, tomorrow.
Yes,
So you,
sir.
so you wouldn't be in session on Saturday.
No, I'll be in the session. At least I could catch part of it.
Yeah, you can log on from wherever you are in Waikiki.
Yes.
And while you're catching a tan, you can just log in,
Yeah, I love.
listen to the rest of us suffer.
Yes, sir. All righty.
No problem at all. No problem at all. Okay, let me get my stash. I'll be right back. Hopefully somebody else will jump in by that time. Okay, great. Here we are. Let me just make it official, see who's in the room. Okay. I don't see Lovette. She's off and running somewhere. I do see Deandra, yes?
Yes, sir.
Indeed, indeed. Siobhan. I don't see Siobhan yet. Leah, I see over there. Notwithstanding, way to go. Melissa,
Hi,
hi Melissa, how are you?
I'm good.
Wonderful, wonderful. Janice, I think I see you there as well.
Yes, I am.
Okay, lovely, lovely. And of course, Alicia going to Waikiki getting a tan, Wilson. Okay, Alicia. Just want you to know we hate you for that. Okay, let's see. Jessica. Jessica must be on Safari as well. All right. So if I can just pull up something here. Does anybody remember what topic we're on today?
Is it Unit 8, special assets?
Yeah, it's Unit 8, Special Assets. So we're gonna talk about those creatures that even trustees hate, actually. And see why certain trustees hate special assets. Special assets tend to give trustees a nightmare for one reason or another. If you haven't seen it yet, you'll see very shortly how this happens. Okay. Unit 8. Yeah, special assets. But before we go to special assets, let's take a moment and go over the assessment questions while I remember, because when we come to the end of the class, I may be just as excited as you guys and sign off without doing it. Okay, so you can pull up your self-assessment questions for accounting. Did anybody get an opportunity to look at it at all? I know, work and study is hell. Work, study, and children is hell. Work, study, children, get married is hell.
Mr. Wilkinson,
Yes.
you sound a bit low or far.
I sound a bit low? How's that?
That's a bit better.
Okay, let me turn the volume up then, see what happens. How's that?
Say again?
Can you hear me now?
Yeah, I can hear you now.
Okay, great, great. All right, let's see if we can get through the accounting questions then. Number one, trustees have a blank with regards to trust assets due to the fiduciary nature of their position.
Would that be a general duty?
Yes, a general duty to. One more word, a general duty to.
Oh,
You're right, you just left out one word.
to account.
Absolutely. Which of the words do you think is the most important? General duty to or account?
To account.
Yeah, absolutely. Thank you very much. Considering that this is the trust accounting side of the trust discussion. All right, number two. The particular interest of blank or remainderment and income beneficiaries or blank are critical in directing trustees to properly manage, invest, and account for trust funds under their care. First blank. It's another name for remainderment. Remember when we were having the discussion, what's another name for remainderment?
Capital beneficiaries.
Absolutely. And what's another name for income beneficiaries?
Life beneficiaries.
Yeah, life beneficiaries, or better known as life tenants. Okay? All right, number 3. Blank of the Trustee Act 1998 gives trustees the discretion to apportion income and capital in a fair and equitable manner in the circumstances. What section is that?
Section 89.
Yes, section 89. Way to go. All right, number 4. Blank of the Trustee Act 1998 statutorily defines the trust fund for the purpose of apportionment. Statutorily. What section is that?
Section 90.
Section 90, yes. All right, number 5. The need for accurate accounting of trust funds is significant in order to avoid blank or blank to beneficiaries and to ensure that the requisite funds are available to meet the requests of both capital and income beneficiaries. What are the 2 blanks?
Overpayments and underpayment.
Yes, overpayment and underpayment. Some beneficiaries don't mind being overpaid until you come and say they have to pay it back. No beneficiary wants to be underpaid, period. Okay? If you overpay a beneficiary and you don't pick it up, then that beneficiary is not necessarily going to come back and say, oh, Mr. Trustee, I'm a born again Christian and you overpaid me, and my good conscience would not allow me to keep the difference, even though it's $1 million over. So let me put this ethical question to you guys. If you're a beneficiary and you're overpaid by $1 million, would you return it?
Yes.
Somebody said yes. Somebody chuckled. Let me think about that one. Okay. Yes. The correct thing would be to return it. Of course. All right. Number 6. Under the Trustee Amendment Act 2013, a trustee of an express trust must maintain reliable accounting records in relation to the following items. 2 key categories.
All sums of money received and expended in relation to the administration of the trust and the matter in respect of which such receipts and expenditures takes place, inclusive of all sales, purchases, and other transactions. And 2, the assets and liabilities of the trust.
Absolutely. Okay. Those are exactly the 2 conditions: all cash transactions and all assets and liabilities of the trust must be available for scrutiny at any time by the beneficiaries, period. Okay. Even if the trustee does not have that requirement to disclose trust accounts, the trustee will then go to the Trustee Act, which makes provision for them to see it. And if there's no act or statutory allowance for it, then some trustees will be, are you kidding me? They'll take it to court. And most courts will typically rule, even if it's not in the deed or not in the Trustee Act, that look, these cash transactions and these assets and liabilities are related to the assets of the trust that are there for the benefit of beneficiaries. We hereby say that you have to disclose. Simple as that. One way or the other, they're going to find out, as they should. Okay, number 7, Section 2 of the Trustee Amendment Act 2013 requires that accounting records, what? A couple of things. Accounting records of
One, correctly explain all transactions.
Yep.
2, enable the financial position of the trust to be determined with reasonable accuracy at any time. And 3, allow financial statements to be prepared. And 4, include the underlying documentation, including invoices, contracts, receipts, and receipts necessary to facilitate A, B, and C.
Absolutely. In other words, have all the documentation in place. Don't say, well, we're not sure what happened, come back next year. We don't really have to account for your trust assets, and they don't want to hear that. The law doesn't require it. Most trustees does not tolerate it. And certainly the courts do not even want to have that discussion. Number 8, the income of the trust fund may be obtained, from blank, 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 and blank.
So that's interest on deposits, dividends, rental income, and loans.
Absolutely, absolutely. And remember when we were talking about it, it kind of outlined all this stuff so that if you had any doubt as to what falls into what category as income and capital, etc., that you had a pretty good idea, a pretty good source of reference to go and have a look to see which one you should categorize what under. Okay, very good stuff. Number 9, expenses related to the protection and preservation of the capital in the trust fund are known as blank and may include those expenses which apply to the trust generally or is considered capital expenditure on the trust assets. What goes into that blank? Known as
Capital expenditure.
capital expenditure. Okay? And then finally, the principal of the trust for accounting purposes is comprised of principal of the trust for accounting purposes is comprised
Of the original trust property inclusive of interest accrued up to the date of transfer, any additions to the principal which the settlor may have transferred or from accumulated income added by the trustee, insurance proceeds from the loss of trust property, stock dividends, and any profits from the sale of trust property.
absolutely. Thank you very much. And so for those of you who are still wondering what goes to capital, we have a pretty clear picture of the key kinds of items that we can actually credit or debit to capital depending on what's happening. Okay. Sometimes even persons who are practicing are not sure what kind of items go on the capital, what kind of items go on the principal. But I think we had a pretty good discussion on that on Saturday as to specifically what goes where. And so for those of you who are actually in the trust world, this little manual that you have, even though you'll be moving on to some other stuff later on, is a great initial source of reference if you need to do a quick study on what's going on and how to apply, should something of this nature come to your desk. Okay. All right, fantastic. So now we can go to,
Mr. Wilkinson, I have a question before we move on.
yes,
If you pay a beneficiary, you overpay them,
right,
and they spent the money and don't have the money to pay you back.
right.
What happens?
By law, they're still liable. Now, if they don't have the money to pay you back, then they will have to find some way to find the money to pay you back, or by getting a loan from the bank, getting the money from somebody, robbing a bank, stealing it, whatever they need to do to get it back. But if none of that is possible for some reason, then when it's time to pay the benefit, let's say it's an annual payment. Let's say it's not, if it's a one-time payment, then you better find a way to get it because the trustee is going to send everybody after you that they can find until you pay. They're gonna sue you.
Even though the trustee is at fault, it's the trustee who overpaid?
Absolutely. Unfortunately, Janice, good question. It's like if the bank accidentally or in error credits $50,000 to your account, you say, Lord have mercy, all my prayers have been answered, and you spend it on everything you could think of and ever wanted to buy. Then the bank comes back with ominous news. Yes, they credited your account in error, but unfortunately in law, you're supposed to know it's not your money, and therefore you should not have spent it. And therefore, they will come after you if you don't make arrangements to repay it. Like the devil in hell they would. Even though, even though it was their mistake. Okay, yeah, but that's a very good question because a lot of people are still not clear on that for some reason. Many persons have had monies credited to their account in error and they spent it. And when the bank went back to them, they raised a holy hell. Like, why did you put it to my account? I thought it was mine. You shouldn't have put it there. It's your error. You made the mistake, so you should pay it back to whomever should go to, and so on. Unfortunately, in the eyes of the law, they hold the account holder responsible. Now, if the account holder suffer any particular loss as a result of the money being credited, and they can make a clear-cut claim that they did suffer some kind of loss, then maybe the court may say to the bank, you made the error, so you have to make good on any losses on that side. But for the customer who spent the money, you are required to repay. Okay, very good question. Because people are still not clear on that and still falling into the trap that if money ends up on their account of any kind by accident, error, otherwise, that they feel that they are entitled to do whatever they want with it. Unfortunately, that is not so. Okay. All right. That is a big time question. A lot of people are affected by that question every single day, including beneficiaries, by the way. There have been beneficiaries that have been overpaid. That's why it's in the chapter, in the discussion, in the trust accounting context, because overpayment is not like every blue moon. Sometimes overpayments occur far more frequently than we would like them to, as do underpayments. In fact, there's a question in some circles as to whether some over and underpayments are made on purpose, hoping that the beneficiary will not respond. Or if a trustee is somehow connected to one beneficiary as opposed to another one, they might quote unquote send an overpayment so that that other one could be better off than the beneficiary they hate. Whatever it is, but sometimes trust matters get caught up in personal issues too, just like other things. Okay, and so sometimes we have trustees who establish relationships with beneficiaries of different kinds. And then we have trustees who have beneficiaries that they don't like because beneficiaries are mean to them or there's been some other discourse between them. And so as a result of this, especially trustees who have a discretionary trust, sometimes they can manipulate things, quote unquote, which of course is not acceptable either. But we are who we are, and some of us still tend to jump off the deep end, trustee or not. Okay. Kind of like those bloody priests who are still molesting little boys. Okay, kind of like that. Okay. Trustees are not supposed to be doing anything untrustworthy. Priests are not supposed to be messing with little children. Same principle, different environments. Okay. Same thing. Okay. So, what are these special assets and what are these underlying companies? That is the question. And we're going to start our discussion by, first of all, trying to determine what is a special asset. Okay. And what is an underlying company? And how do we administer such a trust? And how do we administer these special assets and underlying companies. Those are the questions for today. And if you haven't figured it out already, I think you probably can presume, even without looking at it, that special assets are special because they are a little different from the traditional assets. What can anybody suggest what traditional assets might be? Examples?
Property,
Yeah, property, of course.
vehicles,
Yeah, vehicles,
homes,
homes. But nobody said cash.
cash,
Yeah, I thought somebody said cash first. We always say cash first, even if it's not. We say cash because it sounds like we should say it. But yes, any items like those kind of traditional assets, we call them traditional trust assets. Now, special trust assets, on the other hand, have special features that are a little different from traditional trust assets. And so we refer to them as non-traditional. The markets in which they operate, where we buy and sell them, are non-traditional. Where we trade and invest them are non-traditional. And so because they're non-traditional, they also require very specialized trust and management skills in order to preserve and protect and invest these assets. Okay? And so both personal and professional trustees have intrinsic challenge, we call it, in administering these kinds of trust assets because they are so quote unquote special. Typically, special assets tend to be what we call illiquid. What does that mean, anyone? Illiquid.
can be sold,
Can or cannot?
can, C-A-N,
Oh, illiquid? Not
say
liquid,
again?
not liquid, illiquid.
Oh, cannot be sold.
Absolutely, absolutely. I figured you didn't hear that ill at the beginning. Yeah, illiquid assets either cannot be sold or cannot be easily sold. Okay? Liquid assets, on the other hand, can be easily, much more easily converted to cash or what we refer to as easily dispersed. Okay? But if an asset is illiquid, it is very difficult and in some cases, some feel impossible to convert to cash. Okay? And that's one of the fundamental difference between traditional and non-traditional assets. All right. Now, what do we call these kinds of assets? These tangible special assets. What does tangible mean?
You can see or touch it.
Yeah, we can see or touch it. That is a tangible asset. And of course, intangible assets are those assets that we cannot touch, such as a brand or label or royalty or whatever the case might be. Goodwill and those kinds of things. They cannot be touched. They are there, they have value, but they're not tangible. So the big problem for trustees with special assets is that how do we protect them? Where do we store them? How do we value them and who? And how many people exist on earth who actually have the ability, skill, and experience to value them? And more importantly, how do we market them if necessary? How do we sell them? How do we even buy them? Sometimes buying them is far easier than selling them. You buy them, and then when it's time to dispose of them for some reason, you have all hell on earth trying to find a buyer. And these are the things that make these assets so special. And look at what form these special assets take. Artwork, God forbid. Coins, as you can see. Stamp collections. Imagine having a multi-million-dollar stamp collection and trying to find somewhere where somebody wouldn't steal it, or they wouldn't get dried out or too moist and become destroyed. See? all of a sudden the trustee has to be thinking about all kinds of crazy stuff. If you have cash and land and all that stuff, you don't have to worry about that stuff. Just throw it somewhere, insure it, and that's it. Let it sit. But if you have a stamp collection, you can't just let it sit. You need to find out where you can store that stamp collection so it doesn't get dried up or destroyed by moisture. So that means you have to find a professional to tell you where to put that stamp collection. And while you're finding a professional and doing all that stuff, you have to find a place to secure. So that nobody just picks it up and run with it. Just remember, people are always looking to run off with stuff, whether you realize it or not. Okay? Precious stones are special. Jewelry, antiques, and artifacts, all special assets. So you can see right away that these guys are very different from their counterparts that we call traditional assets. There's nothing traditional about this gang at all. Now, how are these assets transferred to the trust? Same way as traditional ones by the settlor. Okay? Either directly or by donation, in case you didn't know. Okay? In any event, it is transferred pretty much the same way. But because they're so peculiar, I mean, should we even consider taking on these assets at all? That's the big question. And you'd see somewhere along the way in your reading that there are some trustees that will refuse to accept such assets. Can anybody say why? No matter how much money they can make from taking on that responsibility. Why do you think some of them refuse it? Anyone?
The risk.
Yeah, there's a whole lot of risk in trying to protect and preserve that stuff. And remember, if something goes wrong, the trustee is liable. And if the trustee is liable, the trustee will have to pay out of whose money? The trust fund?
Their own personal funds, the trustees fund.
The trustee's personal income. Absolutely. Okay? And so trustees are very wary, even though they could make some big bucks, they can charge a premium for taking on special assets. But some of them have a policy, see? It's not something in passing, it's their policy. We will do any trust work in the world for you, Mr. Settlor, Miss Settlor, as long as there are no special assets involved. Okay? Or perhaps they will take on special assets, but only a certain type, like coins that don't rot, maybe. Okay? They might consider that, but artwork that could somehow the canvas gets messed up because of moisture, or some artifact that can be destroyed by accident, or a little baby earthquake rock stuff and the whole thing falls down and gets broken, whatever the heck it is. Trustees are very wary of taking on this responsibility. But as usual, we always have a couple of high flyers called trustees who will take on any special assets for a fee. Okay, they are the risk takers. The ones who don't take on special assets, they avoid risk. They're risk averse. But there are a couple left out there who will take it on. Now, how do you protect these tangible special assets? Well, finding somewhere safe and secure, like a vault, and the major security, big time custody. Man, all of that is expensive, but that's okay. If that's what you need to do in order to protect the special assets, you pay it. Question: the cost of securing these special assets in a vault under security and custody. Who pays that? The trustee personally or the trust fund?
The trust fund.
The trust fund.
Yeah, the trust fund. Now for the big bomb. Do we debit income or capital to pay it?
Capital.
Capital. Why?
I don't know. I figured that if you debit capital, that's a part of the original capital as well. So they just using it to maintain or take care of the original assets.
Okay, that could be an argument that a trustee could put forth, because if you debit capital, and then when you make your report to the beneficiaries, the capital beneficiaries, and they see that $3,000 is, not 3,000, $30,000 is paid for this particular service, they're gonna know, why did you debit my account or our account as capital trust beneficiaries? Why didn't you debit the income beneficiaries? What will you tell them? Because at this point, they're mad now. Fly over to Nassau just to be in your face. What do you tell them?
Mr. Wilkinson, are eating tacos, you know?
Point well, point well taken.
Okay, let me try and take a stab at it. So that was my first. The first part is what I said, where debit capital.
Right.
So I feel like income is where they're making a profit, or like when you invest and you're getting a return. So if it's capital, that means that that's part of the original asset, and the original asset has to be maintained.
You mean securing the special assets part of the original corpus or assets?
Right.
Okay. Do we have anybody who agrees with Melissa? She's making a strong point. She says that's part of the original assets that was settled, and we're now paying for it to be secured and insured, etc., and safe. Then we should debit capital. Anybody disagrees with that? Based on what we discussed in our accounting session before, as to what should be debited to capital, what should be debited to income?
It
Well,
can come from the income because it could be looked at as operating expenses.
It can indeed. It can indeed. And so the argument raised, and I don't want you guys to think that this only comes up in an academic setting like this kind of class, just for a discussion. These things are real. Both answers are very real. Both positions are very real. These things actually happen in practice. Because in essence, you can debit either capital or income. The real question is, which one is most appropriate? And therein lies the problem in terms of satisfying beneficiaries. And so, yeah, if you consider it to be part of the operational side of things, then we debit income. If you consider it to be preserving capital, the original corpus, then the trustee might argue that that's why we debit capital. What is another solution to this engaging problem? What's another solution to this engaging problem? Well, remember
Can it
that.
be a part of? Oh, go ahead.
Say it again.
I was going to ask, could it be a part of the original agreement?
It could be, or the trustee can decide we'll debit some to capital and some to income. Yeah, and then try and come up with a reason why. A reason that will satisfy the beneficiaries together, both income and capital. Okay, absolutely. So you can see this thing is not just for academic purposes. This is absolutely stuff that happens in the real world all the time. And special assets, non-traditional assets, they do not help the cause. Okay? But it's good stuff. Now, the custody of these special assets must be in a certain kind of care. The trustee has to make sure that they don't just put it into any old custodian's care. The custodian has to be vetted. for the type of business they do, for the security, for their reputation. See? All kinds of little bits and pieces. Just when we thought trying to determine how to apportion the cost of security and custody, we have this thing about finding the proper custodian. Okay? That can give you the specialized terms that trustees need as legal owners of this special trust property, etc., who are ultimately responsible for its protection and preservation. That's a tricky situation for a custodian even. And of course, any custodian that decides to take on that responsibility will obviously be looking to be paid a significant amount of money for the level of risk involved. Okay. All right. Now, we are told that depending on the type of asset that is in question, there are special conditions that apply when we go about storing these special assets you've meant. Already this is a pain in the butt. And the only thing that may be worth being bothered with this headache is being able to get a decent invoice amount for your pain and suffering and worry about whether or not everything will go well with those kinds of assets. Now, especially when it comes to things like stamps and artwork, these kinds of things require a dry and secure and customized, properly temperatured environment. See? All that crap. And none of that is free in order to preserve them. The other stuff require more restrictive security, like precious stones and metals and jewelry. You can't throw them anywhere. Word will get out, even if from somebody who works there. See? A lot of times when things go wrong, you wonder, well, how do they know? Well, because people on the inside talk. Which is why those of you who work for financial institutions, you are subject to our secrecy laws. You cannot just willy-nilly go out and tell somebody what people have on their bank accounts, no matter how you feel. Even if you hate that person, you cannot tell because their information is private and confidential. Okay? So if you see your friend who went to junior primary school and that person has $2 million sitting there, you cannot go and start reporting it to everyone. Okay? Listen, guess what? Janice has $2 million in her account. Who do you think she gets? She must be dealing drugs. Hey, doesn't matter whether it's true or not. We have a duty or confident. Well, if you have a suspicion, you know what to do. Do you guys know what to do if you have a suspicion about a transaction?
If we have a suspicion about,
A financial transaction. What do you do?
file a suspicious transaction report.
Thank you very much. Do you know what happens if you don't file it and you discover not filing it?
Fine or imprisonment.
Oh, Melissa, you've been checking up on this stuff. How come you remember this?
I work at a bank. And then we just had it again in the last session, part 1.
Absolutely. Absolutely. Okay. She has 2 reasons. She works at a bank. And secondly, she's been in contact with it recently, which is why the law also requires that anti-money laundering and terrorist financing training be conducted minimum of once per year by law. So if your employer says we don't have any money to do that one-time training, even though it should be more, that is not justification. They are required by law to conduct at least a minimum of 1 training session on money laundering and terrorist financing and the reporting of suspicious transactions. Otherwise, they could be liable as well. Just in case somebody did not come into contact with that crazy part recently. Okay? So these stones and precious metals and jewelry, they need to be in a restricted area. You can't just have them hanging out on display for people to see and start thinking, oh my God, how can I get those? And so if you're an offshore trustee, like in the Bahamas and Caribbean, you're not on the mainland, so to speak, in other countries. You're an offshore trustee, and so now you have to ensure that these assets under your care and custody are properly filmed. How about that? Filmed each piece, documented. You have to record any important information, what it is, what is it made of, what is the serial number if it has any, what is the model number, any information on that asset, you have to record it in detail and catalog it so that you can find it at any time. You cannot house special assets and the beneficiary comes and says, we'd like to see our assets, and you start digging under boxes and crates and all that. That's not going to fly. Okay? It has to be properly cataloged, properly secured, properly protected in the right environment at all times. And that is how you justify the trustee fees that you get for taking on that incredible and tremendous risk. All right, that's it. I've done enough chit chat for the evening already. Can somebody pick it up for me? Trustees will also. Anyone, just start reading.
Trustees will also have to purchase insurance to cover these tangible special assets in case of loss, damage, theft, or other unexpected events while they are under the care and custody of a custodian or the trustee, provided that the custodian does not have its own insurance coverage for assets under their care and protection that may be suitable for the trust assets. The cost of storage is another consideration for the protection of trust assets, particularly such as assets as artwork, antiques, collectible items, jewelry, and precious stones and metals. The location and cost of storage may prove to be very challenging to the trustees, particularly those which require special attention and certain conditions to maintain their quality and composition while under the care of the trustee and or custodian.
Wow.
Wow.
Keep going.
Wow. Okay.
Keep going.
Oh, while some items may be stored in bank vaults due to their size and nature, other items such as artwork, antiques, or collectibles may be leased to museums or universities by the trustee so that they may be stored and housed in special locations that are adequately equipped to accommodate such items. The trustees must balance the cost of storage of tangible special assets with the risk of preserving and protecting such items whilst under the administration of the trustees. The valuation of special assets normally requires the expertise of a qualified expert or assessor who is able to properly value the assets and determine their true worth. Depending upon the nature and rarity of the special assets, there may be only a few experts who are qualified and able to properly assess and determine the value of certain special assets. This small supply of qualified experts in certain instances drives the cost of valuation of the special assets and presents a significant challenge to the trustees of the trust. However, the valuation of special assets is necessary to purchase adequate insurance for the protection of such assets against loss, damage, or theft.
Big job. Keep going.
Another challenge in holding tangible special assets under a trust is the problem of finding a ready and available market to sell such assets when required. Oftentimes, the sale of such assets are done at auction through reputable auction houses. Additionally, exclusive private collectors and dealers may have to be engaged in the sale and auctioning of these assets, which may require additional time, cost, and efforts in arranging and finalizing the sale or auction. It is important that particular tangible special assets such as painting, artifacts, and jewelry do not remain in the houses or under the care of the settler or his family due to the high risk of such items being stolen, lost, or damaged, and not fully covered by relevant insurance. Additionally, trustees must consider the application or attraction of certain taxes to such assets, such as estate taxes, if the special assets are held in jurisdiction outside of the Bahamas, which levy estate taxes in certain instances, particularly those instances where the assets are under the custody of the settler and there are legal disputes regarding the ownership of the assets for the purposes of the tax laws in the particular jurisdiction.
Thank you so much, Janice. That's some heavy material with regards to these bloody special assets. I think you've probably been able to figure out by now why a lot of trustees don't want to mess with them. Because as you can see, preserving and protecting them is a big time job. Finding somebody to value them for insurance purposes is another problem. The valuators are few and far between, and the few that you find, you have to make sure that they actually are legitimate and they are not fakes who are in fact valuing your assets, or that they're not compromised in any way to over or undervalue those assets, believe it or not. All kinds of strange things happen in this business, especially with millions of dollars are involved, and especially where somebody can find a loophole to get a cut or a percentage. I know, like really, could that be in trust special assets as well? Cuts and percentages can be anywhere. Doesn't matter where it is, as long as people can get together and make a deal. Doesn't matter what the environment is. A deal, albeit a negative position, can always be made. Okay, so we are, even as trustees, we are not even allowed to underestimate this particular aspect. This is a very real issue. Okay? And so the trustee must now balance the cost of all of this storage and preservation, etc., and decide, do I really need this headache? Can we really afford for something to go wrong? Do we have our own insurance and to indemnify us in case something goes wrong? All kinds of questions, a long list of questions. Okay. Now, remember, I mentioned these experts. A lot of people say they're experts, but are they really experts? How do you determine whether somebody who's looking at artifacts and paintings, etc., are truly experts? That means you have to shop around to reputable institutions like museums and others to see if you can get them to collate the story that a particular person is qualified to do this job. That's a lot of time and stress and dealing with different people and trying to make an assessment as to what is legitimate and what is not. Not to mention that because valuers do not come a dime a dozen, their fees are extremely high. Plus, they know if they make a mistake of any time and it's very substantial, we know what can happen. They can be sued. They know this too. And so whatever fee they charge you, it's designed to cover that kind of risk, and in some cases to cover their indemnity insurance in the event they're sued. So this trustee business is a big old nightmare when it comes to special assets. Okay? And so again, many trustees shy away for obvious reasons. Acquiring these things are not easy. Selling them in the market is not easy. Never was and never has been so far. When these items have to be auctioned off, you need a professional auctioneer who knows what they're doing, who knows how to come up with the right starting bidding price. Who knows when the final price makes any sense or not? It's a whole long, drawn-out process when dealing with these kinds of assets. Very different from traditional assets and how we manage them. Right? Just when we thought traditional assets were a headache, we have this gang called non-traditional assets. And they are completely different kind of animal. And to make matters worse, she said, she being Janice, she said, make sure that these assets are not kept at the settler or his family's house. Now, folks, why would that be in this text at all? Why would that make sure be in this text? How come? Anyone? Do not keep it in the settler's house. What does that suggest?
Because that would mean that the settler is managing the assets of the trust.
Yeah, first of all, the settlor is managing the assets of the trust, which should never happen. Because stuff can go missing and they say somebody break in and stole it. When in fact, they just hide it somewhere. Declare it stolen, collect some insurance money, put it into the trust fund as additional corpus. Are people really that devious, Klaus?
Based on the movies, yeah.
What about real life?
I'm sure there are people.
Yeah.
Yeah, she said based on the movies. I know. It's so incredible to believe that some of that movie stuff could be true, but much of it is true. In fact, the movie part of it is the romantic side. We just see little bits and pieces of the reality. In the real world, it's much more intense and much more devastating. Okay? Just like when somebody gets kicked in the head in the movies, we kind of get the feeling it hurts, but it's not the same as being kicked in the head in real life. Because first of all, in the movie, they're not really being kicked in the head. True? But in real life, we're being kicked in the head. Same principle. So we have to be very careful. The assets should not be in the settler's house. The settler should not be controlling the assets that have been turned over to the trustee. That's why they're turned over legally to the trustee. But we have some settlers who are beneficiaries and they make arrangements with the trustee through pressure or stress or some other engaging exercise to get them to actually agree for some of these assets to remain in their home. Since the settlers trust is paying a couple $1 million to the trustee every year, the settler reminds the trustee that this trust can be revoked based on the conditions that I have. I don't need you to upset me about this. I want my feelings on my wall at home. I'll protect them. We can arrange to insure them, but I want them in my possession at home. When I get up in the morning, I want to see them. During the day, I want to come home from lunch and caress them. At night before I go to bed, I want to look at them. Or else, if you don't let me do this, I'm going to take away my trust and give it to someone else, one of your competitors. And so you, the trust administrator, feel stressed and decide to go along with it, even though you should not. Right? Under no circumstances should that happen. And let's not forget the tax implications. Like the text says, most of this stuff occurs, or some of this stuff occurs, these assets are located outside of our jurisdiction. If it's in the Bahamas, we can control it, we can make certain decisions about it. If it's not, if the assets are not in the Bahamas, it becomes a bigger problem. It means that wherever they're located, that jurisdiction will exert its law and its pressure, and anything else it needs to if necessary. And certainly, they will not be considering offshore jurisdictions or anybody else for that matter. It becomes a self-interest program. But the key thing about the jurisdiction is making sure that the beneficiaries understand the tax implications of the money they're receiving. They need to understand that if you, the trustee in the Bahamas, send them $1 million in the United States, so that $1 million is income and is going subject to tax. And the same as in Canada or any other country where you have to pay income tax. Okay. Of course, if it stays in account in the Bahamas, there's no tax applied to it, and many settlers and beneficiaries who settlers who are beneficiaries and other beneficiaries, they try to take advantage of this situation. Okay? Wow, special assets. Now we can see what makes them so horrendously special, but not special in the way that we fall in love with them, even though they are good to look at, we know the value of them, but special in the sense that they are not subject to the same protection and preservation requirements for other assets. And that could become, on any bad day, a nightmare for a trustee. What? Some trustees are risk takers. Remember, they'll do it for the right fee. All right. Who just read? Janice, was that you who just read?
Yes, it was.
Okay, great. So I need somebody to back Janice up now. A pinch hitter. Special companies. I don't feel like pinch hitting. Any pinch hitters in the room other than Janice? You're a trustee, be bold. You're going into a meeting of a very main stinky beneficiary, and you're gonna have to make your point clear. How's that? Let's see if that campaign works. Anybody wants to pick up from Janice? Special company.
Trustees may be asked to manage closely held companies that may have been owned and operated by settlers before transferring their full and/or controlling interest to the trustees. These closely held companies may require specialized skill and expertise by the trustees due to their nature and complexity. Since the ultimate liability for these special assets is that of the trustee, many trustees, particularly offshore trustees, may refuse to accept such assets into a trust. The management challenges involved with these companies have caused certain offshore trustees who decide to accept and administer them to include anti-partlet clauses in their trust instruments as a form of indemnity for any claims or actions that may be related to the management and operation of closely held companies under the administration of trusts.
Keep going.
Sorry. The
No
case of Bartlett versus Barclays Bank Trust Co. Limited is one which involved the management of a closely held company by the trustees of the trust and explored the particular considerations, responsibilities, duties, and obligations that the trustees have when accepting these assets in trust under their administration and management.
Before you go on, Deandra, have you guys come across the Bartlett versus Barclays case in your previous sessions? No, it didn't come up in your previous sessions before now? Yes, no? Bartlett versus Barclays Bank.
So I honestly don't remember it. Not saying that it didn't come up, but I don't remember.
Actually, yeah. When you guys get a moment, you can actually even type it in Google, Barclays versus Barclays Bank, Trust Company Limited. And just look at the summary or the synopsis to see what the reference is here with regards to special assets. Something peculiar went on with that trustee relationship, and it didn't always go well. But have a look when you get a moment. Keep going, Deandra.
Trustees often elect to serve as directors of such companies to ensure that their proper governance and management, or appoint certain experts to manage such companies on their behalf. If the trustees manage such companies, there is some consideration for the risk exposure involved in their administration of the trust, and fees are set and adjusted accordingly. Trustees are encouraged to carefully consider whether the type of business of the closely held company, its income and expenses, the business's accounting, the existing management of the company, the provisions of the trust instrument, which allow and authorize the administration, management of such companies, and relevant legal protection, and their qualifications and expertise in managing such companies. Professional trustees also hold shares in companies in accordance with the prudent man of business rule, which required that a professional trustee decide and act as a prudent man of business, would in being aware of his investments and ensuring that his investments are made prudently, profitably, and expeditiously.
Keep going.
J. Cross in the Bartlett case stated, the conduct of the defendant trustees is, I think, to be judged by the standard applied in Spites versus Gantz, namely that a trustee is only bound to conduct the business of the trust in such a way as an ordinary prudent man would conduct a business of his own. Now, what steps, if any, does a reasonable prudent man who finds himself a majority shareholder in a private company take with regard to the management of the company's affairs? He does not, I think, content himself with such information as to the management of the company's affairs as he is entitled to as shareholder, but ensures that he is represented on the board. He may be prepared to run the business himself as managing director, or at least to become a non-executive director while having the business managed by someone else. Alternatively, he may find someone who will act as his nominee on the board and report to him from time to time as the company's affairs. In the same way, as it seems to me, trustees holding a controlling interest ought to ensure, so far as they can, that they have such information as to the progress of the company's affairs as directors would have. If they sit back and allow the company to be run by the minority shareholder and receive no more information than shareholders are entitled to, they do so at their risk if things go wrong.
Interesting.
The Bartlett case outlined the prudent man of business rule and requires a professional trustee as shareholder to monitor and intervene in the affairs of a company which the trustee has a shareholding interest, particularly a majority shareholding, as in the case of Bartlett versus Barclays Bank Trust Company Limited.
Just keep going.
Justice Brightman stated that the bank as trustee was bound to act in relation to the shares and to the controlling position which they conferred in the same manner as a prudent man of business. The prudent man of business will act in such a manner as is necessary to safeguard his investments. He will do this in two ways. If facts come to his knowledge which tell him that the company's affairs are not being conducted as they should be, or which put him on inquiry, he will take appropriate action. Appropriate action will no doubt consist in the first instance of inquiry of and consultation with the directors, and in the last but most unlikely resort, the convening of a general meeting to replace one or more directors. What the prudent man of business will not do is to content himself with the receipt of such information on the affairs of the company as a shareholder ordinarily receives at annual general meetings. Since he has the power to do so, he will go further and see that he has sufficient information to enable him to make a responsible decision from time to time, either to let matters proceed as they are proceeding or to intervene if he is dissatisfied. Jay Brightman concluded his judgment by stating, "In my judgment, the bank wrongfully and in breach of trust neglected to ensure that it received an adequate flow of information concerning the intentions and the activities of the boards of BTL and BTH. It was not proper for the bank to confine himself to the receipt of the annual balance sheet and profit and loss account, detailed annual financial statements, and the chairman's report and statement, and to attendance at the annual general meetings and the luncheons that followed, which were the limits of the bank's regular sources of information. Had the bank been in receipt of more frequent information, it would have been able to step in and stop and ought to have stopped Mr. Roberts and the board embarking on the Old Bailey project. That project was imprudent and hazardous and wholly unsuitable for a trust, whether undertaken by the bank direct or through the medium of its wholly owned company. Even without the regular flow of information which the bank ought to have had, it knew enough to put it upon inquiry. There were enough obvious points at which the bank should have been intervened and asked questions. Assuming, as I do, that the questions would have been answered truthfully, the bank would have discovered the gamble upon which Mr. Roberts and his board were about to embark in relation to the Old Bailey site, and it could have and should have stopped the initial move towards disaster and later on arrested further progress towards disaster. I have indicated in the course of this judgment a number of obvious points at which the bank should have intervened, and it would be repetitive to summarize them. I hold that the bank failed in its duty, whether it is judged by the standard of the prudent man of business or of the skilled trust corporation. The bank's breach of duty caused the loss which was suffered by the trust estate. If the bank had intervened as it could and should have, that loss would not have been incurred. By loss, I mean the depreciation which took place in the market value of the BT shares by comparison with the value which the shares would have commanded if the loss on the Old Bailey project had not been incurred, and the reduction of dividends through loss of income. The bank is liable for the loss so suffered by the trust estate, except to the extent that I shall hereafter indicate.
Wow. What can I say? Thank you very much, Deandra. That's the story behind the Bartlett case. If you didn't pick up on the gist of the Bartlett case by now, the judge, even though he spoke about being repetitive, remained repetitive, because I think he wanted to make it clear that the Bartlett case was strictly about using the prudent man concept in conducting business. And basically, what the reason for that whole reference is to remind us as students and trustees and trust administrators that whenever a trust has an underlying company where the trustee of the trust owns 100% of the shares or the majority value of the shares, that trustee has a duty to act as a prudent man would, and typically that would mean the trustee would want sufficient information to be able to determine if things are going right or wrong with regards to the company. What does prudent man involve? Prudent man involves getting regular information about the business itself, the company's operation. The prudent man involves sitting on the board as a trustee or having a nominee sit and report to you as a trustee. A prudent man might appoint himself as a majority shareholder, as the managing director, so that they can be involved in the day-to-day activities of the business directly. All of these things are what we consider the prudent man's approach that is available to any trustee that owns an underlying company. Unfortunately, sometimes when trustees have these underlying companies, they allow the persons who are always running the company before it goes into trust to continue to run the company, and sometimes they run it into the ground. And so when we get to the question of Bartlett and the judge's accusation against the financial institution or the bank and saying you are liable because had you provided or intervened in the operation of this company, then the trust itself would not have suffered the losses that it did. And so therefore, you didn't act as a prudent man would. And the company itself has suffered. The shares have been devalued. The dividends have been reduced. The company did not perform as well as it could have had you stepped in and done something about it. And by extension, the trustee now has to take into account these negative results that have come up as a result of not following through with the prudent man approach. So going forward, whenever you hear the Bartlett case, Bartlett versus Bartlett Bank, you know it's about taking the prudent man's approach and making decisions as a trustee with regards to underlying companies. And anybody who's responsible for ensuring that these companies are run the way they should and do not take such actions could be liable at the end of the day for not acting as a prudent man would. All right, thank you very much, Deandra, for plowing through all that legal mumbo jumbo. But it does go ahead and explain, I hope, a little more carefully the concept of the prudent man concept under Barclays and how the trustee has to use whatever means possible to make sure he knows or she knows what's going on with an underlying company if such a company falls under the purview of the trustee. Remember, typically when there's an underlying company, the trustee will hold 100% shares of that company or certainly the majority shares. And therefore that means that the trust now is suddenly responsible for the proper functioning and continuance of that company. Okay? Which is a huge task because sometimes the company has a couple of $1 million that they earn every year in sales or whatever given type of company. And oftentimes the company can be a multi-million-dollar company. And God forbid, in today's world, it could be a billion-dollar company sitting as an underlying company under a trust, being run by a bunch of God knows who. And so now the trustee has the responsibility to make sure that those directors and senior management people are doing their jobs by preferably sitting on the board, getting all the information that they need to get to ensure that things are going according to plan. Big, big, big job as the company, as the underlying companies get larger and larger under the trusteeship of the trustee. All right, great stuff, Deandra. You went through all that crazy stuff without blinking. That's truly amazing because that was a whole bunch of this and that. All right, who's going to pick it up from Deandra? Commercial real estate. Another special asset.
I could read.
Okay, Lovette, when did you join us?
Yes.
Let me make note of that so that. Okay, Lovette is here. Excellent. Okay, Lovette, commercial real estate.
Okay, commercial real estate. Certain special assets may be in the form of commercial real estate. Some commercial real estate may be of a particular nature, such as mining operations, farms, wineries, and other commercial interests, which require more special skill and knowledge to operate and manage properly. Trustees often hold these types of assets in underlying companies. and hold the shares of such underlying companies which represent their ownership interests. There should be certain provisions in the trust instrument which allow the trustees to repair, upgrade, carry out construction, mortgage, insure, and do certain other things that a typical legal owner would do in relation to his property. The imposition of certain taxes, levies, rates, assessments, and license fees on these commercial real estate properties, particularly those in foreign jurisdictions, may prove very challenging to offshore trustees in the management and administration of such assets under their care. As with other special assets, the trustees should appoint persons with the relative expertise to properly manage these commercial interests, particularly those which require more specialized knowledge and skill. Other special assets. The trustees may have certain speculation and risky investment instruments under their administration, such as derivative, options, or future contracts. Due to their nature and the use primarily in hedge risk in most investment portfolios, trustees should be very wary to include them in their investment strategies, particularly when they consider the nature of the trust assets and specific needs of the beneficiaries of a trust, which may be unsuitable for such assets. It is important that trustees properly review and consider the suitability of certain investment securities when deciding to accept certain assets or invest generally. Their ultimate responsibility is to protect and preserve the assets in the trust and ensure that they act in the best interest of the beneficiaries in the administration of the trust. Underlying companies. Trustees often hold certain trust assets through ownership of shares in underlying companies. In offshore jurisdictions, these companies are normally international business companies, IBCs, which have special features which allow the trustees to minimize their risk, expense, operation, and management. To ensure additional governance, management, and oversight of these companies, the trustees often have corporate or individual directors who act on behalf of the trustees as shareholders. As directors, there are certain legal duties and responsibilities that are owed to the shareholders of the company and to the company generally. It is critical that shareholders of such companies, particularly trustees of trusts, be given information regarding the overall management, governance, and corporate oversight in a timely and professional manner in order for certain important decisions to be made. Special assets are held more conveniently through underlying companies, as they allow the ease of control and management by the trustees. In most offshore jurisdictions, such as the Bahamas and the British Virgin Islands, IBCs have no capital gains, corporate or other taxes, and the cost of incorporation and administration is relatively inexpensive when compared to other corporate vehicles. In addition to the relatively low cost of incorporation, exemption from taxes, and ease of operation, IBCs also allow trustees to maintain the level of confidentiality and anonymity that is required in the operation and administration of offshore trusts.
That's it. That's where you stop, Lavette?
Yeah, that's it.
Okay, great, fantastic. So again, she extends the discussion from from that earlier crazy Bartlett case about how trustees need to be informed and anybody responsible and acting as a prudent man needs to know what's going on. By extension, commercial real estate is another special asset that has all kinds of things attached to it to make them work. And if they occur as an underlying entity, it only makes it even more intriguing for the trustee who now has responsibility for making sure that all the requirements under this particular area called real estate as an asset are properly accounted for, managed, protected, insured, whatever the case might be. And I don't know if you guys are aware of it, but managing commercial property is no easy task. It's a nightmare depending on where it is, what it is, how large it is, etc. But these kinds of things, as a trustee, these kinds of special assets can eventually end up in your care and be settled in the trust with you. And once you decide to take on this responsibility, remember you already said special assets, especially like special needs children. I think everybody has an idea about special needs children. Special needs children are a little different from children who are not special needs children. And so special assets are very different from traditional assets, the same principle. They require much more work, much more care, much more direction, and much more protection, just like special needs children, interestingly enough. Okay? And we are told that whenever these kinds of assets exist in underlying companies, where the trustee holds the shares of these underlying companies, then there should be certain provisions in the trust instrument, see, which allows the trustee to do some normal repairs and maintenance and management of these properties. Otherwise, if it's not in the trust instrument, that could tie the trustee's hands. And if the trustee tries to do some maintenance work on these properties, the beneficiaries could complain and say through their lawyers, it's not in the trust deed. And then, of course, that's going to piss the trustee off. Like, are you kidding me? So how is the thing going to be maintained? They say, we don't care. It's not in the deed. What do you think the trustee might do, anyone, under those conditions?
Retire?
They might try to retire, like, I don't need this headache, but some of them don't retire. They want that fee income, millions of dollars per year. So they don't want to retire. They want to continue as a trustee. What do you think they might do other than retire? Take it to court.
Oh,
Remember, if it's not in the trust instrument and you try to do some maintenance and the beneficiaries complain, try to get you to stop, and you don't have the avenue to the trustee because it's not there for some godforsaken reason, and there's nothing under the trustee act that will cover you for these special assets, then the only other alternative you have is to go to court. And as trustee, your lawyer has a good case, Your Honor. How the hell are we supposed to maintain these assets if we can't take the money out to do it? And what do you think the courts are likely to do under those conditions? What would a prudent judge do? How is that?
Rule for the trustee.
Of course. And his answer is going to be, his response is going to be simple. He might say something like this. It is regrettable that the beneficiaries have sought to take action against the trustee in a matter such as this. This is a very simple, practical, and commonsensical situation. If these assets, special as they are, require maintenance for their perseverance and protection, it is only fitting that the trustee be allowed to use trust funds in order to maintain these assets. Perhaps it may not be clear to the beneficiaries and their lawyers who brought this action in defense against the trustee. However, in my wisdom and my judgment, the trustee has every right, and then close the case, get up and leave. And that's the beauty when things work at the court level. They don't always work that well. Okay, but that is an option. And then coming down the stretch, we were reminded once again that the trustee has control of underlying companies the trustee has to be a prudent man again. Sit on the board, have somebody sit on the board, manage the company, have somebody manage the company, get feedback on a regular basis, not do bits and pieces, proper reports, proper financial statements, proper sales reports on a monthly basis, quarterly basis, annual basis, so that the trustee, because remember, no matter how many people are running the underlying company, whatever type of business it is, at the end of the day, the trustee is still responsible for the results, good or bad. Okay? Remember we said earlier at the beginning, a trustee can delegate duties but not responsibility. The principles say, or the same principle applies for underlying company, okay? Underlying companies under the trust. Now, the problem we have sometimes the problems we have in offshore jurisdictions like the Bahamas, where you know, we don't have all the relevant taxes that they have in other jurisdictions. And that's one of the reasons some jurisdictions didn't particularly like jurisdictions like ours, because companies would come over and set up business incorporated in the Bahamas, and have the Bahamas or the somewhere in the Caribbean or Bermuda or Guernsey or somewhere as their company base. And since there are no taxes in this jurisdiction, then there's no taxes to be applied to the income that is generated by the company, even though the company is in another jurisdiction. And a lot of countries where the company is physically doing business, they're not happy with that, because they want the company's head office or business office to be in a position where they could tax them and get their share. Instead, they're sitting in a tax-free jurisdiction like ours and not having to pay tax because their company is incorporated here and not in the other jurisdiction where tax applies. Okay? Hence, this big old battle now to get corporations to return to their home countries so that they can be fully and effectively and completely taxed, which of course many companies are not happy with. And of course, those companies that do not do it, the EU and FATF, OECD and company are now getting ready to put what we call a minimum tax. I think it's 15% on all jurisdictions. So we don't charge any company taxes. That minimum tax will apply to all jurisdictions offshore like ours. And I suspect if we do not comply with that requirement, then we will face the consequences as we've always had to face with black listing, gray listing, blue listing, purple listing, green listing, tangerine listing, every listing you can think of. Okay? So, as you can see, these special assets then become a real challenge. It's a real nightmare. But like I said earlier, there are trustees who are prepared to take a chance. And then there are many others who will not touch it with a 10-foot pole. Okay? All right. So I think then that we have pretty much exhausted the nature and life and circumstances around special assets. We have certainly determined why they are special. We have certainly determined where they exist. We've certainly determined the challenges that they present for the trustee and trust administrator, particularly in offshore jurisdictions. And so as a result of that, I think the story here is any trustee is able to assume responsibility for these special assets, but most trustees know that they have to take them on with care, because there is no question that keeping special assets is like keeping special needs children. Okay? Big, big, big job, and you have to love it in order to make it work successfully. All right. Are there any questions at this point? Wonderful. So what you have a couple of things to do for Saturday then. Number one, I need you to go ahead and do the assessment questions for the night session. and Saturday session. My, lot to do in 48 hours. And also, I would like you guys to write down this statement. Are you ready?
Yes.
Okay. Please write this statement down. Review the rights, comma, RIGHTS, if any, comma, of an object of a discretionary trust. Review the rights, if any, of an object of a discretionary trust. Any of those words, have you heard any of those words before in your life? So far from trust one and up to now.
Yes.
Yes, I would hope so.
Are you meaning object as in the beneficiaries?
Well, I'm so happy that you were able to connect it right off the top of your head. That is definitely part of that question, yes. Unless, of course, we refer to objects in some other capacity. Do we or not? Typically, when we refer to objects, we are referring to
Beneficiaries.
beneficiaries, yes. So, review the rights, if any, of an object of a discretionary trust. So what rights pretty much do beneficiaries have, if any, within a discretionary trust? That, along with the two assessments, is your now for the objects of a discretionary trust question. Please, you don't have to write 4 and 5 pages unless you're really feeling like you're on a roll somewhere. I just want you to come up with a response as completely as possible, because I would love to hear on Saturday how students responded to that question about the objects of a discretionary trust and their rights, if any. Okay. Now, when you have completed your write-up, please send it to me by email. And on Saturday, as part of our final discussion, we will look at some of your thoughts on that particular question. Remember, it doesn't have to be a long 3 and 4 page essay, but it should be sufficient that talks about what the objects are and what rights do the objects have within the discretionary trust, if they have any rights at all. So that should get your whole gray matter going. Open up your part 1 if you have to, look up that information on objects. Go online and find out what folks say about objects of a trust, and if they have any rights in a discretionary trust, etc. And see how creative you can be in 1 or 2 pages if you're the person who wants to write 1 or 2 pages. Please send them to me so I can review them before Saturday, and we can have a discussion about your thoughts on those matters. Everybody get all that?
Yes.
Wonderful. Remember, this is not designed for you to pull out your hair, lose your nerve, spank the children, and make your spouse miserable. It's not designed, not designed to do that. Just designed for you to go out and do a little research and write up on that particular topic. Email it to me so we can discuss it on Saturday morning, right?
Okay.
Wonderful. Okay, you guys, take care, and I shall see you within 48 hours. Sounds pretty ominous, but I'll see you in 48 hours. Please be careful and take care.
Okay, good night.
Good night, everybody.
Good night.
Good night. Good night.